Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Azza Amisha binti Azmi. My matric number 1222064. And as introduction, I will briefly discuss the procedure of arrest and search in Sharia law. So basically, arrest and search are essential procedure in the Sharia criminal justice system, and they play an important role in helping enforcement officers investigate offences, to collect evidence and ensure it in compliance with Sharia criminal law. So without this procedure, it would be difficult for an authorities to carry out effective investigation and enforce the law. So, however, the power of arrest and search cannot be exercised arbitrarily. So they must be carried out lawfully, fairly, and in accordance with the procedure prescribed by the law. And this is important to prevent abuse of power and to protect the right of individual involved in the investigation process. Also, Sharia law seeks to strike a balance between effective law enforcement and the protection of individual rights, dignity, and privacy, while enforcement authorities are given certain powers, and these powers must be exercised responsibly and within legal limits. So basically, in Malaysia, the procedure relating to arrest and search are governed by the State Sharia Criminal Procedure Enactment, and this law provides the legal framework that guides enforcement officers in carrying out their duties. So in conclusion, proper compliance with arrest and search procedure helps ensure justice, accountability, and public confidence in the Sharia legal system.
My name is Amra, and now I will briefly explain the constitutional validity of arrest under Sharia criminal law and the safeguards provided under the law. Firstly, Article 5 of the Federal Constitution protects a person's liberty by ensuring that arrest and detention are carried out according to law. In addition, Article 5, Clause 4 requires that an arrested person who is not released must be brought before a magistrate within 24 hours and cannot be detained longer without lawful authority. In addition to that, Section 2 of the Sharia Courts Criminal Jurisdiction Act 1965 provides that Sharia courts only have jurisdiction over persons professing the religion of Islam, and the courts are also restricted to the 365 limit in the punishment that they may impose. Next, a key provision under the Sharia Criminal Procedures Law Enactment 2003 is Section 10. So Section 10 grants the power of arrest to religious enforcement officers, police officers, and other authorized persons. And Section 10, Subsection 3 also acts as an important safeguard by prohibiting the use of force that may cause death during the arrest process. Further protection is also provided by Section 14, Subsection 1, which states that an arrested person must not be subjected to more restraint than is necessary to prevent an escape. And additionally, Section 22, known as the 24-hour rule, requires a person arrested without warrant to be brought before a Sharia court judge without unnecessary delay, and that person cannot be detained beyond 24 hours unless a remand order is obtained. So the importance of these safeguards can be seen in the case of Qasim Alliance Osman bin Ahmed. So the court in this case found that the authorities failed to follow the required arrest procedures and detained the appellant beyond the lawful period, which is 24 hours, resulting in a violation of his rights to personal liberty under Article 5, Clause 1 and Article 5, Clause 4 of the Federal Constitution, which is similar to Section 22, Subsection 3 of the Sharia Criminal Procedure Enactment.
Assalamualaikum warahmatullahi wabarakatuh. My name is Siti. My matric number 122069. So I will explain the statutory framework governing search procedure under the Sharia Criminal Procedure Federal Territories Act 1997. So this act gives religious enforcement officers the power to conduct search during criminal investigation. So the purpose of a search is to obtain evidence, locate suspect, and assist in the investigation process. Unlike the Sharia criminal procedure, search can be divided into two categories, which is search of a person and search of premise. So a search of premise is carried out to find suspect or evidence related to an offense. according to section 11 and 12 of the Act, allow search of premise when there is a reason to believe that a suspect or evidence is located there. Generally, officer must obtain a search warrant before conducting the search. So section 44 governs the issuance of search warrant and act as an important safeguard by ensuring that search are authorized by the court and not carried out arbitrarily. In urgent situation, section 63 of the Act allow reos to seize document or object connected to an offence and where necessary conduct a search without warrant to prevent evidence from being concealed or removed. So the Act also protect individual right by requiring personal search to be conducted by an officer of the same gender, in line with Islamic principle of modesty and privacy. In conclusion, this provision provide a balanced, effective law enforcement and the protection of individual right under Sharia criminal procedure. Thank you.
So for my part is about the Islamic jurisprudence in this research article journal. So I will explain about the taftish al-ashkhas. Okay, so taftish al-ashkhas, it means that the investigation or search of a person by the authorities to determine involvement in criminal wrongdoing. It was including also with the searching for weapons, stolen property, illegal drugs, or other evidence. And in the Islamic law, these searches is generally prohibited because they may violate an individual's privacy and was quoted in the Surah Al-Baqarah verse 190, which prohibits transgressions against others. But this prohibition is not very absolute because a search may be permitted when there is a reasonable suspicion or it was supported by sufficient evidence or coroner to justify the investigation. And we can see the position of Taftish al-Ashkhas, which is according to Ahmad bin Abdul Karim, it was divided into two categories. First, Siyasah Syariah, and the investigation procedure and criminal charges will fall under Siyasah Syariah, while the determination of offences, conviction, and punishment will fall in our jurisprudence. So, we can look at the how to relate with this Taftish al-Ashkhas with Islamic legal maxim. First, we relate with al-darar yuzal, which means harm must be removed. It was a very fundamental principle in Islamic criminal procedure. It requires authorities to prevent and eliminate harm while ensuring the justice. Like in Surah An-Nisa, verse 12, this ayah prohibits actions that cause harm to others, and therefore any such procedure must balance the law enforcement objective with the protection of the individual rights and freedom. Also, we relate with the legal maxim of al-darurat tubihal mahzurat, which means that necessity may temporarily permit what is normally prohibited, but this permission is limited strictly to the extent necessary and cannot be used as a general justification. So in the context of these search procedures, searches are not allowed for every type of crime. However, the application of searches will depend on the nature of the offence and the jurisdiction involved, and the specific circumstances of the case.
Okay, so now I will explain further on the legal loophole and the procedure of arrest and search in Sharia law. So the first one is about the uncertainty of the reasonable suspicion requirement. Although the police officer might arrest someone without a warrant, actually the law does not provide what is actually a reasonable suspicion. So this creates uncertainty in the enforcement. So the second issue is the risk of inconsistent enforcement. Different officers rely on different sources such as anonymous complaint or personal observation. So without a clear legal standard, similar cases might be treated differently. The concern regarding privacy and abuse of powers. Raids on private places may be conducted based only on the complainant without sufficient evidence. This raises concern about their privacy and possible abuse of powers. And from Islamic perspective, this actually conflict with the principle of tabayun, which means requires verification before taking an action. Islam protects personal privacy and prohibits unjustified intrusion. So, another issue is about judicial review. So, when the law does not provide an objective criteria for reasonable suspicion, the court may find it difficult to assess whether the police action is actually reasonable or just speculative. Then, about the threat to presumption of innocence, people who may face arrest and detention before sufficient evidence is obtained. So, reputational harm may occur even the accused is actually innocent. Finally, it's about the need for legislative reform. The law should clearly define reasonable suspicion, establish objective criteria, and require verification of the complainant. Actually, this reform will improve accountability and protect individuals' rights.
Assalamualaikum. My name is Asha, and moving on to the second issue, which I will analyze the body search in respect of human dignity and aura under the Sharia criminal enforcement. Okay, so first, body search is referred to a process of discovering and recovering any possible evidence and proof from a suspect physical body. So the main purpose of body searches are to obtain evidence, to facilitate criminal investigation, and to prevent any concealment of evidence. Okay, so body searches are legally recognized under the Sharia Criminal Procedure State of Selangor Act 2003, particularly under the section 12, 14, 15, and 17, which the enforcement officers are empowered to conduct body searches on arrested person. However, the exercise of this power must be balanced with the protection of individual. Firstly, from the perspective of human dignity, Islam actually recognizes that dignity as an inherent right of every human being. So Allah stated in Surah Al-Isra, verse 70, that He has honored the children of Adam. And further, this principle is reinforced by the narration of Abu Hurairah, where the Messenger of Allah said that the whole of a Muslim body, his property, his blood, and his honor are forbidden for another Muslim to violate. So therefore, every person, including a suspect, deserves respect. There must not be humiliated and retain fundamental dignity despite being under investigation. So, as a result, body searches should be conducted privately, avoid unnecessary exposure, avoid any degrading treatment, and should be limited to legitimate investigation purpose only. Secondly, body searches may affect the protection of aura. So, since exposing or revealing our aura is generally forbidden in Islam, so body searches can only be justified based on the legal maxim ad-darurah tawbi al-ma'zurah, meaning that necessity renders prohibited act permissible. However, this is limited by ad-darurah taqaddar bi qadariha, meaning that necessity is limited to its extent. So, therefore, the authorities should use the least intrusive search method possible and try to minimize any exposure of aura. Furthermore, Section 14, Subsection 2 of the Sharia Criminal Procedure State of Selangor Act 2003 requires that body searches must be conducted by an officer of the same gender as the suspect, meaning that the female suspect must be conducted by the female officer, while the male suspect must be conducted by a male officer. Okay, so this requirement is very important because it protects aura, it protects the dignity, it ensures the compliance with Sharia principle, and also avoid unnecessary embarrassment. However, in real life, in practice, the lack of female officers may create operational difficulties and increase the risk of procedural violation.
So, as the conclusion, the procedure of arrest and search are crucial in ensuring the effective enforcement of Sharia criminal law while providing enforcement officer with the authority to investigate offences and obtain relevant evidence. And at the same time, these procedures safeguard individual rights and dignity by ensuring the enforcement actions are conducted lawfully, fairly, and in accordance with the principle of justice under Sharia law. Thank you.